Morning all, happy Sunday. I thought I'd use today just to go into a bit more detail about the bankruptcy and how it's intrinsically linked with conspiracy and collusion between TLT and the trustees. Back in 2015, received a bankruptcy petition order notifying me of a hearing at Maidstone County Court. It's for an account for Screwfix, which I was on the understanding has been settled. The amount was £3,137.60, with no substantiated knowledge or details of how there was a breakdown, how it come to that figure. I knew that the figure on the account which I'd settled was 1,800 odd quid. So I wrote back to the court and to Screwfix and asking them to give me a breakdown, because that's the only document that come through the post. So I responded, went down to the court. The hearing was set for 2 o'clock. I went and spoke to the court usher with a bit of paper. He said, no, there's no hearing listed for you. He showed me the listing. He said, you're not on it. He said, go and use the phone the court central listings office, which I did. Phoned the court central listings office, give them the name, the address, details. They said, no, we've got nothing for you. There's no record of any hearing taking place today. So I went back to see the usher. I said, what's going on here? Something's not right. I said, this clearly states there's a hearing here today at 2 o'clock. He said, wait there, let me go and find out. Off he went, come back. He said, there was an urgent email about this yesterday. Let me find out. Anyway, he took me into this little room, private chambers, Deputy District Judge Swales. Ted, it's Frisbee. Where is it? So took me into this room, stood there. He said, sit down. I said, I'm fine standing, thank you, sir. I said, look, before we start, can someone tell me what's going on? I said, there's no record of a hearing taking place. I haven't been given any paperwork, any documentation. You don't sit down. He said, I'm calling security. I said, well, hold on. I said, look, I've had 6 knee operations. I mean, 6 or 5 at the time. I said, look, I just wish to remain standing. I said, before we start, I said, is there some kind of rules that I need to be made aware of? Because I haven't been given any documentation, a breakdown of where this alleged debt's come from, etc. With that, he pressed a button. 2 security come in, went to grab hold of me and said, we're removing you. I said, don't touch me, obviously that's assault. So I've left, and I said, I don't consent to these proceedings. He said, the hearing's going to be heard in your absence, and that was it. Went back home, hand delivered through the post box was all the paperwork. Apparently there was a CCJ and all the breakdown of where it come from. So what it was, there was a CCJ put on for £2,107.60. Ted, come on. £2,107.60, and the bankruptcy petition was for £3,137.60, exactly £1,030 more than what was on the statutory demand. Now, the insolvency rules 1422 practice direction says if a bankruptcy petition is for a statutory demand only, the amount that's on the stat demand must be the same that's on the petition. So, and it wasn't. I've requested a transcript of the hearing for the recording, and also the judge's handwritten notes. The court transcribers come back and said, unfortunately, the audio equipment wasn't working on that day, so there's no audio file, there's no transcription. Also, there's no judge's notes. But he did write an email to say that because it was only a simple matter of bankruptcy, that he didn't refer to the red book, and it was only a matter of just making sure basic checks was in place, which obviously wasn't. So, under further investigation, I found out when I went down to go and view the case file, the senior court manager at the time, Samantha Thompson, I had an appointment to go and view the case file. She said, what are you looking for? I said, I don't believe Screwfix have paid a fee to initiate the proceedings. So of course they would have, there'll be a receipt in here. So she went through the files, there wasn't a receipt, there was no evidence on the claim form, and then she went and printed off the caseman file, which proved there was no entry. She said, no, you're right, there's no evidence on the court that their fee's been paid. Now after that I found out that an application for a bankruptcy petition was £280 and £750 that to be paid to the official receiver. 750 plus 280 is 1,030, exactly the same difference as what from the stat demand to the bankruptcy petition. And with the evidence they haven't paid a fee, it seems like Screwfix have obviously got this on account, or something's happened with the court where they've actually made my person bankrupt for money that they couldn't prove owed for the application, which they can't do because there has to be a breakdown. on the actual petition. So with that, after I got home, all the paperwork was obviously sent through. A week later, there was a notice come through the door saying, upon hearing Toby Lee in person, is declared bankrupt. Well, he didn't hear me in person because I got ejected from the room for no reason, just for asking questions, what jurisdiction, etc. So a day or two after that, I went straight online, went onto the Screwfix account and checked the balance was still outstanding, 1,879 quid. So I went online and settled it, paid it, cleared the debt. I then spoke to Shoesmith Solicitors and said, look, what's going on? The debt's been set. What's it going to make this go away? And he wanted 5,000 odd quid. But he gave the breakdown. It was 3,100 quid, which was the petition amount, plus 1,100 quid legal fees, plus another 1,030 quid for the application and official receivers. So that's evidence of trying to unjustly enrich themselves. So I was challenging that from 2015 up to 2018. They went to court. They got a possession order for Toby Lee. The name is very key, because when I went to the Chancery Court, one of the Clips barristers up there said that the name has to be correct, because I could be John Smith, you could be John Paul Smith, two different entities. And the name of the entity that was not made bankrupt, and on the forms it was wrong, it was Toby with a Y, Toby with an E, Toby Lee, trading as Toby Lee. It was all over the place. So they said it has to be correct, and it wasn't. So that went on, and then they applied for a possession order, and they said that Toby Hayden Lee in bankruptcy. There isn't a bankruptcy order for Toby Hayden Lee, but there is one for Toby Lee. But Toby Lee's got no assets. Toby Hayden Lee did. Now, obviously, this is all what I've recently found out about the insolvency, that in 2015 the bankruptcy threshold was 750 quid, and 2016, late October 2015, it was going up to 5,000. So Screwfix have pulled this CCJ out rather than go for bailiffs and rather than go for a charging order on the property. That they went straight for bankruptcy. But I think that's because they couldn't get a charging order on the property, because the name on the bankruptcy order was different from what was on the title deeds. So anyway, so that's gone on. We went through the possession that the trustees in bankruptcy applied, and they replaced my name for being the proprietor of both the properties in 2018, after they took the property a month out of time. The bankruptcy order was June 2015, and they come and took the property in July the 9th 2018, which is 3 years and a month. Now, after 3 years, the property automatically gets vested back to the bankrupt. It should have done. And that's the reason when I took the property back, they didn't come back after me again, I believe. So now we move on to this current state of affairs, where the trustees in bankruptcy, the bank have written to the trustees, and the trustees have basically said they didn't want nothing to do with it. Now, the problem they've got is that I was not the correct named defendant in the party, as Toby Hayden Lee, as my person on the possession application. Because the trustees, I've got nothing in my person's name. It's registered in the trustees in bankruptcy. So although they've disclaimed the property, they never notified me at all of the disclaimation. They never notified the Crown Estates. They never notified the Land Registry. And you can see that in the letters I posted last night. Because when TLT wrote to the Crown Estates and said that the property's been deemed subject to a sheet, they said we weren't aware of it, and then chased them up and asked them for a copy of the disclaimation, which they then sent. And even the Crown Estates have said that we don't oppose, although we don't support the application, and we've got no express view on whether your claim's valid or not. So the property is in, well, no man's land. But when they disclaimed the property, it should have automatically been vested back to me, and it wasn't. So now the trustees in bankruptcy are saying it's deemed subject to a sheet. The Crown Estate is saying it's nothing to do with them. But on the Land Registry, it's still registered in the trustees in bankruptcy. So they were the correct named parties to be the defendants in the proceedings. So this whole claim is absolutely based on fraud. The bankruptcy is void, which is what they're relying upon. And now with this going on, with the possession, I mean, TLT were fully aware of the bankruptcy, because they've been served notice of the application, so they know. They're solicitors, they're lawyers. The trustees know that the debt was settled. All of these lawyers in whether it be in Screwfix, whether it be for the trustees, whether it be for TLT. They're all lawyers. They're all trained in law. They know it's completely baseless, but yet they're still proceeding. And this is where the criminality and negligence comes along, because we've got negligence from the trustees because they've got a duty to protect the beneficiary and the creditor, because I am penultimately the creditor. It's my signature that creates the funds, as we all know. But the fact is, the debt was settled. The amount was settled with Screwfix. It's offer and acceptance. I went onto the account, settled the amount that was outstanding. That should have been it. It should have ceased, but it didn't. It went from the official receivers to Mazars, and they've continued and tried to get an order for a possession and sale of 2 properties worth 600 grand for an £1,800 debt, which had been settled. So, the fraud and collusion and corruption is deep on this. And they're in it up to the eyeballs because they've all got knowledge of it. So, I'm just going to carry on shining a very bright light on the truth. It's got to stop. There's got to be get to a point where there is going to be. You just want to sit around the table with a judge or someone and say, right, this is what's gone on. This is what the law is. Are you going to apply the law or not? But we keep going. Sun's shining. Ted's enjoying his frisbee and his walk. So have a good day, rest of you. Bye bye.